So let's jump in, and here we go. What's the first thing I should do when I get my hearing notice? And it sounds pretty mundane, perhaps it sounds pretty simple. What do you do when you get a hearing notice in the mail? I should redact the name out of here. Hearing notice. They look like this. Hearing notice. Notice of hearing. That's it. It comes in the mail, and it's a notice for a hearing. What do? Don't throw it away. Open the envelope. These are things I shouldn't have to say. You don't know how many times people come in here, whether it's a new case or somebody I've represented or somebody I've represented for years on 15 different cases, and they come in and they say, "We got all this mail from the comp carrier and the board," and I look at it and it's all still sealed in the envelope. Open your freaking mail. Open it and look at it. So what should you do when you get your hearing notice? You won't know it's your hearing notice until you open it. Open your mail. But once you get your hearing notice and you know you have a hearing, call your lawyer. And if you don't have a lawyer, get one, because you don't want to go into the lion's den where the judge works every day, where the insurance company attorney works every day, and you've never been before without somebody there to protect you. And if you need a lawyer, I know somebody. He looks like me. He's sick right now. 212-406-8989. Feel free to give me a call. But yes, first thing you should do is call your lawyer or get a lawyer. Even if you just have a consultation and you decide that you don't need a lawyer, fine. But just get an understanding of what to expect. If you have a lawyer, confirm the hearing, the date, the time, the format. Now, in New York, we're still doing virtual appearances still. And I see it never changing because it makes it easy for everybody. It takes a little of the luster off of the going in front of a judge and doing it with the judge looking at your face and evaluating for credibility and things like that. But that's the way it is. But I know in other states and other jurisdictions, they still do have live appearances. And there might still be some level of live coming back to New York. But right now, we're still doing virtual only. I'm hurting. Confirm all the specifics so you're available, so your lawyer's got it on the calendar. Make sure. It's simple. Lawyers make mistakes too. Make sure that everyone has it on their calendar so that you're good to go forward. Start reviewing. Well, really, I'm looking at my notes here. And my bullet points are out of order. What is the purpose of the hearing? That's the most important thing. Talk to your lawyer. Why are we having a hearing? What is the purpose of the hearing? Is it for my testimony on whether the accident actually happened or not? Or is it an administrative hearing to determine whether or not a disputed hospital bill should be paid or not? You need to know the purpose of the hearing, because if it's something that is relying on you and your information and your testimony and your facts and your evidence, well, then you need to get ready for it. So find out what the purpose of the hearing is, and then start reviewing your timeline, your accident, your treatment, your work status, all the important, relevant facts that you're going to need at your fingertips when you go to this hearing. Excuse me. Whew. So understand the purpose and prepare for that purpose. Is it testimony? Do I need to go see the lawyer and have a trial prep session with the lawyer? Are we talking about medical treatment? Are we talking about permanent disability? Are we talking about loss of wage earning capacity and vocational factors? The YouTubers, I'm sorry, the Instagrammers, I was cutting my face off a little. What's the purpose of the hearing? Understand it and prepare for it, and get the help from your lawyer. There's far too large a percentage of my clients all over that just don't care or think, the lawyer's got it, he'll take care of it. And the ones that actually call me and say, I got a hearing notice and it says it's for average weekly wage or permanent disability. What can I do? What can we do? What are we going to do? The ones that want to be in the know, want to be prepped, those cases go better. We're all on board. They know what to expect. They don't. Those are the clients that don't call me after the hearing and say, what the hell just happened in there? Well, we did everything that we discussed before. So if you have an expectation and understanding of what to expect, what the purpose of that hearing is, you're going to come out ahead. And then if it's testimony, set a meeting to prep with your lawyer. We try to, it's hard to keep on top of everybody, but we call people. We try to within a week before that trial date, a week being the longest, but we try to get them, within that 1 week period to come in, sit down. what questions to expect, what questions am I or my attorney is going to ask you, what to expect from the insurance company or the judge. Um, you need to be comfortable. I man, I don't know how specific I want to get. We had a client recently who had it was she told me that she wore a hand and arm brace, and they have her on video not wearing the brace. And I asked her, "Do you wear this brace all the time?" And she said, "No. If my arm hurts, if my wrist hurts, if my hand hurts, I wear the brace. If I feel okay, I don't wear the brace. When I sit down to eat, I take it off. If I'm playing with my grandkids, I don't wear the brace. I don't always wear the brace. Sometimes I wear the brace, not always with the brace. No brace, brace. Fine. We go to court. Ma'am, do you always wear your brace? Yes. Does there ever come a point in time that you don't wear your brace? No. You wear it 100% of the time? Yes. I You see my bald spot got a little bigger? That's why it got bigger. I was shredding hair out of my head. What you told me one thing, and my feeling is that person just wasn't comfortable sitting there. And what happens is you get uncomfortable and it takes control of your brain, and you kind of you get foggy eyed. You lose sight of reality. And I've seen it happen. I can't even begin to tell you how many times people have come in here and I've prepped them, and I'll prep them. We'll discuss what to expect. We'll go over it. I'll do a little mini trial, and I'll tell them this is how the trial is going to go. We're going to swear you in. And sir, were you working on September 5th, 2024? Yes. And what type of work do you do? And I try to run through it. And sometimes you could tell by body language. And people, if you're not comfortable, you're going to F it up. Get comfortable, prep with your lawyer. If you even after a prep, if you're still not feeling it, talk to him some more. You got to get into that comfort zone. Um, it could be a scary environment. And it's really not. What I always tell people, the Workers' Compensation Board and here in New York State is like, it's like going to the Department of Motor Vehicles or whatever the incarnation of your DMV is in your state. It's the DMV with a judge. It's really not a big deal. But if you're not comfortable, if you don't feel that confidence, you're gonna put your foot in your mouth, and you got to be super careful doing that. How do I prep with my lawyer the right way? Okay, well, the first thing you want to do is you want to be upfront and honest about past medical history and intervening accidents. If this is a back case, make sure your lawyer knows if you've ever hurt your back before. Make sure your lawyer knows if you had a car accident 2 weeks after your workers' comp accident. All important stuff. Those are super important things. Make sure your lawyer knows whether you're working or not working. And it's not always a black and white issue. Volunteer work, working at your brother's store, running the cash register one hour a day while he runs out for lunch is work. Um, there's a lot of different activities that could be construed as work. And the judge will ask, some judges will ask, are you doing anything that could be construed as work? It's a very open-ended question. Be careful. Talk to your lawyer about it first so you know how to prepare for those questions. You don't want to stick your foot in your mouth. It's super important. You want to get those big things out of the way. Then you want to just go over your medical history, your treatment that you've gotten, the treatment that you're expecting. Is there a big surgery on the road? Injections, MRIs, EMGs? What are your doctors discussing with you? And what are you expecting to happen to you down the road? Go over your wages with your lawyer. Make sure that the board has the proper wage set, and your compensation awards are proper. Your work status we discussed. Have you gone back to work, full duty, light duty, same employer, different employer? All important information. Always be upfront and honest about everything. It's always best, even if it hurts you, to throw it out there ahead of time and let it hurt than to have it come back and be a lie, because then it's really going to hurt. Okay. Practice key questions based upon the hearing type. So understanding the purpose of the hearing, your lawyer will then explain to you what the hearing type is going to be. People ask me all the time, am I going to have to speak? Am I going to have to speak? Well, if it's a trial where you're set to testify, yeah, you're going to speak. But even if it's a hearing that's on for continuation of awards, you're probably going to have to speak anyway. Mr. Smith, have you gone back to work since the last hearing? No. No work whatsoever? No, not even volunteer work? No, nothing. Great. You should be prepared for that, because that's an important question. It probably happens here once or twice a year where a simple hearing like that, a 3-minute hearing, where that's the only question to my client. Sorry, since the last hearing, have you gone back to work? No. I get a call the next day or 2 days later from the client. I think I might have lied in court. And I said, what do you mean you might have lied in court? They asked me if I went back to work. I went back to work 2 months ago. And I said, well, why the hell did you tell him no? I don't know. That's what came out of my mouth. And that happens far too frequently. And it's bad because now it just puts a blemish on your case. Now I have to have you draft an affidavit explaining your mistake, hope that they're not going to hammer you. And unfortunately, that's going to sit in your file. And every time they call your credibility into question, they're going to say, oh, that's the guy who completely lied to our faces at a hearing. So be prepared. Be prepared. You want to practice key questions based on the hearing type. If it's a permanency hearing, if they're going to talk about your limitations, if they're talking about your vocational background, your schooling, your prior jobs, your ability to read, write, and speak English or other languages, have an understanding of what to expect so that you can go in there confident and comfortable. If it's a trial that's going to the basic, we call it ANCR here in New York State, accident, notice, and causal relationship, the elements of a case. If it's an ANCR trial where we're basically determining, did you get hurt at work? Did you give notice? And is it all related? You really want to make sure you get prepped for that. Questions are flowing. Love you guys. I'm trying to zip through the slides so I can get to some questions before I absolutely rip my throat out. Which documents should I organize before the hearing? Here's what we started doing here. I'm going to show you. You come to the law office of Rex Zukovsky, you get a law offices of Rex Zukovsky folder. And that's beautiful. And it's a regular folder, like you had your social studies homework in school, and you have a folder. And why do I give the folder? Not because I'm trying to advertise. It's nothing special. It's so you keep all your papers together. This way, you never have to organize everything. If you keep your papers in one place, I didn't get a bag. We have bags here too. If you have a very big file, we'll give you a whole stinking bag to throw your paperwork in. This way, all your papers are together. I've told people from the first day I ever started practicing, keep all your papers together, please. I love when clients come in, they say, I got a letter in the mail from the insurance company or the board or from you. And I'll say, what letter are you talking about? I don't know. I didn't bring it. Why would you not bring it? Or when they come in and they say, I got all these letters here. And then I look at them and there's family court orders in here. There's bills from the electric company. Some of them have food on them. Like, guys, let's get serious. Keep your comp paperwork together. We'll give you a fancy folder. I'll give you 2 folders if you want. Keep your papers together. Be prepared so it's all in one place. Try to put them in chronological order. Keep your medical reports together and keep them in date order if you get those. A lot of people don't get the medical reports. They get sent automatically to the board. We have an electronic version of them, but doctor's notes that you give to your employer. IME reports. You'll get an IME notice to go see the doctor to get the report. Keep them together. Keep them in order. This way, if we're here talking about it, and you say, wait, at that IME, this happened, and I'll say, what? You could pull it right out. Boom, there it is. If wages are an issue here in New York State, I'm going to want to see your W-2s for the year leading up to your accident. So if you got hurt in June of 2024, I want to see your 2024 taxes and your 2023 taxes. I'm going to want to see your June 23 to June 24 pay stubs. I'm going to want to see any proof and evidence, anything you got that's going to show what you earned from June of 23 to June of 24. Take your date of accident and go backwards 1 year. I'm going to want as much documentation as I can get if average weekly wage is the issue. And if benefits are the issue, average weekly wage is the issue. We want to get that average weekly wage as high as possible to get your benefits as high as possible. If you work a second job, we talked about this last week. Did we? Concurrent employment? I don't know. I'm always talking about it. If you work a second job, give me the pay stubs. Get me a letter from your boss saying, yeah, he worked here on June 15th, 2024. And the next morning he went to his regular job and he fell off a ladder. Well, great. It helps us. Oh, man. W-2s, job duties. Yes, the year before. Doctor's notes. What we discussed. Keep them in chronological order. Make it easy. If you're home and you're not working and you're watching freaking Price is Right all day and you're playing Candy Crush on your phone, you could take 7 minutes out of your day to take the letter that came in the mail that day, put it in your folder in order. Don't just jam it in there. Have some respect for your case. Show the judge, show me, show the carrier that you're serious about this. You respect the system, you respect the process, you respect their time, and you want to move forward. Take the time to do it right. Please and thank you. Doctor's notes, any documents showing attempts to return to work or job search efforts. Work search documentation. So if you've been ordered to do a work search, you have to demonstrate labor market attachment. You are going to need 17 folders because this will not hold it. You need to look for work. You need to look for a lot of work. You need to show the judge that you're going out of your mind to look for work, and you need to make sure you keep all that evidence. The more, the better. You have the power to create evidence in a work search situation. If the judge is ordering you to look for work, you now have been given the ball. You have now been given the power to make evidence in a case, something which never happens in any legal setting under the sun. It's so rare that they're saying, here, take this and make your own evidence to support your claim. Do with it what you must. And if you drop the ball, I can't help you. You have been given the opportunity to make evidence. Go out there and look for work. Look for work within your restrictions. Look for work that you could possibly do based upon your doctor's limitations. The possibilities are endless, and you have that ability to go look for work. I can't. The people who understand that concept versus the people who say, "No, I'm not going to do it." I can't. I don't get it. I don't get it. You're given this chance to make your case valuable and important. And people are like, no, it's too much of a hassle. Well, you're not working. Go look for work. Keep all that evidence very nicely organized in your folder that we give you. That was a rant. That was important information, though. Like it or not, maybe because I'm not feeling well, I'm a little angry today, and there's a chip on my shoulder. Deal with it. How do I get ready to testify without hurting my case? Prepping and getting comfortable. And sometimes that means going home and running through those questions in your head. Sometimes it's doing it out loud. I do an out loud fake trial with every prep I do with my clients. What you want to really focus on, you want to practice giving short, clear, concise answers. Keep your answers as brief as possible. If you can answer a question with 2 words, don't use 4. Answer the question and wait for the next question. Everybody wants it. It's I'm doing it now, and I can because I'm not testifying. Everybody wants to ramble and give all the information in one breath, in one answer, in one sentence, and be done with a situation that they're not comfortable with. That is not how it works. You will do much better if you listen, take a breath, take a second, listen to the question, think, what are they asking me? And answer just the question. There will be more. There will be a lot more. Wait for each question. You ask somebody on January 1st, where were you working? And next thing I know, they're telling me about their cousin who lives in Peru. I'm not asking you these questions. It happens when we take medical testimony and you ask a doctor a question. Next thing you know, he's running away. Doc, my question was very simple. I'm asking you this and you're talking about that. Listen, take a breath, take a pause, and then answer the question and keep it brief. Taking that breath and taking that pause is more valuable than you could ever imagine. It keeps you from sticking your foot in your mouth. Good question, on point. So I'm throwing it up here, VMBLV. Can I have translation in the hearing? Yes, you can. If you require an interpreter here in New York State, they will get you an interpreter. So that's a fantastic question. Again, that pause, that break, that breath, super important because it prevents you from verbal diarrhea, as they say. Okay, you don't want to have verbal diarrhea. Um, don't guess. Don't ever guess. Even if you say "I guess" and you're telling the judge, "I don't know. I'm just guessing," they're still going to use it against you. Don't guess. Don't guess, because if they're you got to remember this, and this is the one of the golden rules of being a lawyer, being a trial lawyer, asking questions under oath. As a lawyer, you're told don't ever ask a question that you don't know the answer to. If they're going to ask you a question and your answer is "I guess," you're guessing at a fact that they know. And if you're wrong, they're going to make you look like a schmuck, an idiot, whatever word you want to use, for not knowing a question that you should know. So don't say "I guess," just say "I don't know." You're better off saying "I don't know. I don't recall. I don't remember." Be careful. Saying "I guess" is going to hurt you. I don't remember. I don't recall. That's fine. Our TikToker is outside. Pardon me. Is it active? Does he have decisions? Um, Keith, I didn't skip you. I answered the one question that was on point during my rant. I'm going to get to more questions. Trust me, Keith. No guessing. Focus on facts, not feelings. Okay, and that's really the truth. We do workers' compensation. I'm not splitting the atom here. I'm not doing cutting edge constitutional theory. This is comp. This is something that most people who have the time and the energy to review certain law books could understand and handle on their own. Why do workers' comp lawyers have a job, and why do we do what we do? Honestly, and this goes for a lot of different areas of law, we take the emotion out of it. You give me the law, you give me the facts, we put them together, we present them to the judge in the most favorable light, and try to get you a good outcome. You're dealing with people that are hurt at work. People who are hurt at work, they work for somebody. They have a boss. I can assure you, if you go to any of my own staff here, they think that I've been an asshole before. Everybody thinks their boss is an asshole at some point in time, if not all the time. Bosses are assholes. And now you're in court on a case where you got hurt working for an asshole. There's a lot of emotion involved. You got to cut the emotion out. Okay? It's facts. What happened? Who'd you tell? Where'd you go? What'd you hurt? How much did you earn? Facts. It doesn't matter that he said this and he was supposed to do it. Doesn't matter. It really doesn't matter. Most of that stuff is just extra BS. Like I said before, the elements of a workers' compensation case, accident, notice, and causal relationship, those are the ingredients to bake the cake. Okay? I don't care if my cake, I don't need a big, extravagant wedding cake. I need a crumb cake. I need a pound cake. I need the most basic cake possible because, in my opinion, cake is cake. I just want to bake the cake. I just want to get the elements in to bake the cake to show them that you have a case. If you start throwing too much crap into the batter, you're not going to get a cake. You're going to get junk. Keep it simple. Keep it factual. Cut the emotion out, please. I want to discuss crying. Do we want to talk about crying right now? Crying hurts a lot of times more than it helps, but let's not go there. Please don't volunteer information. When a question is asked, answer the question. It is a human, it's instinctual. If there's a pause, a lull in a discussion, that somebody has to jump in and fill in that silence. And you don't know how many times you'll ask a question. How many days a week do you work? I work 6 days a week. And then the lawyer's looking for the next question. But there was this 1 week 7 years ago that I worked 7 days that week. Like, whoa, just shut up. Bear with me, folks. I'm sorry. Now's a good time for you to all get water. Excuse me. Wow. back again. Sorry about that, folks. They were running behind, and I wanted to make sure I could help. So, don't volunteer information. We're back. Mentally prepare yourself, and this is where the comfort and the confidence comes in. You got to stay calm under pressure, especially if you're testifying on the facts surrounding the accident and the notice and things like that. It can get hot. It can get hostile, and some insurance company attorneys can look to smack you around, make you feel bad, make you feel stupid. You gotta keep cool. You can't let them get under your skin. It's not a schoolyard fight where you want to walk away at the end and say, "Hey, I got the best of them." You don't want to win the fight because that means you're fighting. You don't ever want to fight. You just want to answer the questions and move on. And if a question is hurtful, if the answer to a question you don't think is going to be favorable to you, sometimes you just spit out the answer and let's move on. We were taking testimony of a doctor yesterday who I was asking about lumbar flexion. Lumbar flexion is your ability to flex forward at your waist. And he's telling me that, in his opinion, 60 degrees of lumbar flexion is normal. So I would say that 60 degrees, 90 degrees is that. 45 is half of that. So 60 degrees is a little more than. And my question to him was, Doctor, you're saying that 60 degrees is normal flexion. Wouldn't you agree that there's a huge percentage of the population that could bend at the waist 90 degrees and touch their toes? Well, and we went on and on with every incarnation of this question for a couple minutes before we moved on. And afterwards, I was talking to the attorney, and she's like, why didn't he just say, yeah, you're right? It would have just, now we have 7 questions that make you look like an idiot instead of 1. So think about that. If they're asking a question and the answer is not one that you think is gonna help you, it might be a hurtful answer. Sometimes it's easier just to answer it and move past it. Get it out there, get over it. Don't try to dance around them sometimes. And this is why you need to have an attorney. You need to be prepared. Whew, my throat is on fire. Rehearse your answers to questions. Do it out loud. Do it with your lawyer. And then talk to your lawyer so you can anticipate the questions that are going to come your way, so you know what to expect, so you're comfortable. That's really all this comes back down to, is being comfortable. What are the biggest prep mistakes people make, and how do I avoid them? Not prepping with your lawyer when it's time for you to give testimony, big mistake. Waiting too long to reach out to your lawyer. Not getting an understanding as to what to expect when you go to court, showing up unprepared. Huge mistake. This is a big moment in your life, a big moment in your case. Be prepared. Give it your best shot. Giving long-winded or emotionally driven answers hurts more than it ever helps. Limit your answers. The judges don't want the emotion. They want the black and white. They want the what happened, where did it happen, how did it happen? And the emotion really, it muddies the waters. We don't want to do that. Remember, we want to bake that cake. That's all we want to do, is just get those ingredients in and get the elements checked off and move on. Not reviewing all of your evidence, not preparing your evidence ahead of time. People will scramble and get me pay stubs, and there'll be weeks missing, and they'll be ripped. I should have had this stuff a long time ago so we can get it. When I get pay stubs, I compile them. We put them into an Excel document, so we have a cover sheet that shows all the math is done, and it's nicey nice. Give me a chance to do that for you. And missing your hearing entirely, big red flag. Big red flag when you just don't show up, and it happens. And look, sleeping late is not an excuse in my opinion, but I understand that life happens and sometimes you miss, but it doesn't look good when you miss a hearing. Try to beat all your hearings. All right. I'm going to try to get into a couple questions here, folks. I probably have 10 minutes of voice left. If I could feel the swell. So, Larby, IME doctor listed me as having been in jail on a report. One only time, appealed and sealed. I'm assuming that he did this just as a dirty act to muddy the water and taint the case. It wouldn't matter. So I'm assuming it was true, and he mentioned it in there. Why he would do it, I don't know. I wouldn't worry about it too much. Um, it's not gonna it's not gonna make that big a difference. We've seen it all here. These judges have seen it all. I wouldn't let it bother you too much. Gilbert, I have a rep for the BRC and don't have confidence. What's a BRC? Nobody has all the med records. Gilbert, I need to know what the BRC is. I'm assuming that's like the Workers' Compensation Board in your state. If you don't like your rep, go out there and speak to other attorneys. You're allowed to. At least I think you are. Here in New York State, you are. Cooley. Lee. Hi, Rex. I went back to work on light duty. I did light duty for a month and then they sent me home because no more light duty. Who pays me while I'm out of work again? Well, if they let you go, so if you were working light duty and you were earning less money and there's a reduced earnings claim, you have that. If it's documented that they're letting you go because there's no more light duty, then you should be able to get compensation again. I'd like to see that documented, but you should be able to make that claim. That's where cases get tricky and convoluted, but make sure you have a good attorney because the insurance company is going to try to steamroll you into saying, you were fired and you're not entitled to anything. So be careful. My therapy has been suspended due to my uninsured employer. What should I expect? Are you in New York State? Uninsured employer claims are different throughout the country. Comp is different throughout the country. Uninsured employer, especially, every state has its own little way of handling that. And it could be suspended due to the carrier if you had a carrier there. Suspensions on therapy happen a lot. I just had a hearing call and they're telling me that it's no money on my case due to overpayment. That was a mistake done by my lawyer or workers' comp. Now I'm screwed. Talk to your lawyer. Ask them where this overpayment comes from and how you can resolve it. There might still be money left after that overpayment is absorbed and resolved. So talk to your lawyer. Gilbert, lawyers won't touch my case. It's been over 2 years. What's this? If the statute of limitations is 2 years, like here in New York State, that's probably a good reason. Lawyers still have to make money. We still have businesses to run. And unfortunately, if a case is not going to put food on the table, excuse me, man, I'm just being gross. Sometimes you got to turn a case down. Unfortunately, I'm sorry for the sneezing and the bad news. Callahan, Big Tom Callahan's son. Hello, Rex. I received many calls and mails from non-governmental agencies talking about my Medicare, even though I did not reach 62 years. Is it scams? Probably. What is happening here? Are we back on Instagram? My Instagram just spontaneously paused me. Probably because somebody clown-faced me again. Probably a scam. If it quacks like a duck, and you know how it is. Gilbert is in Texas. Texas doesn't care about injured people. It's nothing like New York. Ask somebody in New York how they feel. And I do still make great points, even though I am sickly. Callahan, I reached almost 2 years from the date of surgery waiting for a Section 32 agreement. Is it true that more I wait, more I have a good lawyer knows how to negotiate? I don't know what you're asking me. Waiting doesn't necessarily make your case more valuable. Sometimes it makes your case less valuable. State insurance fund will factor in what payments they've made. If they offered you $100,000 a year ago and then they paid you 10 grand over the last year, sometimes they'll now reduce their offer to 90 grand. Having a good lawyer, though, like this guy, sometimes can salvage money, make your case worth more. Whew. I'm sorry. I got two questions left because I'm fading here. Hi, Michael. I had a case open. I got hurt on 1/20/25. Disc herniation was found at L5S1. Patient has been administered for 6 visits. Ortho appointment has been approved, but not scheduled. 1.5 months so far. I'm not understanding. Total claim denial. Was injured 1/20, terminated 2/20, went to the doctor 2/22. It's a Florida case. You texted him on 1/21. Do you have a lawyer? I have a great lawyer in Florida who might be able to help you out. If you need help, give me a call, 212-406-8989. Rebel, I have 4 different doctors that say I need neck fusion C3 to C6. That's like your whole neck. But the insurance company keeps denying it and went to a level 3 and was also denying. What are my options? Depending on how it was denied, perhaps your lawyer can ask for testimony, or your Your doctor can resubmit the request, so there's a possibility for that. I told Keith I would answer his question. Keith from California, the judge ordered the defense to calculate future medical by April 30th. Will this come up at my next trial date of 5/15? Keith, I don't know. I don't practice in California. I don't know California law. I wish I could answer your question, my friend, but I don't know. If you don't have a lawyer in California, you need help finding one, call me. I do know some attorneys out there that are doing great jobs. Whew. And they should be able to help you out. Folks, I'm signing off. My throat is on fire, and I wish I could stay. But next week is a new week, and sickness be damned, I will be back for more. Okay. How does Thursday sound? Let me just check one thing here. Sai, you with me? Thursday, May 15th. I'm just pulling up my calendar here. Schedule. Thursday, May 15th. Thursday, May 15th. 4 p.m. 4 p.m. Putting it in. YouTube Live. Folks, please, I apologize for my lackluster performance, my hoarse and raspy and horrible voice, the sneezing, the coughing. I apologize for it all. I am a human being. And but come back next week, Thursday, 4 o'clock. Natalie, I see your question up there. Please come back Thursday, 4 o'clock. I will get your question answered. Or call me, 212-406-8989. I won't have to yell over the phone. I can have a nice, quiet conversation with Natalie, with Hood Rich, with Callahan, with get your midnight right, get your mind right. I'm sick in the eyes. See you next week, folks. Thanks for sticking with me. Love you guys. Thank you.